Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're taking a deep dive into family arbitration. Many of you might know, but family arbitration is a form of private dispute resolution in which the couple choose together an arbitrator who is impartial and fair to resolve their dispute. The arbitrator really acts as a private judge, which means that they make a decision for the couple, as opposed to a mediator or a collaborative lawyer who helps to facilitate a negotiation. To give us a better understanding of what family arbitration is and also how it works in practice, I've invited Rebecca Hawkins. Rebecca is a specialist in non-court family dispute resolution, and she's trained and experienced as an accredited mediator, a family lawyer, an arbitrator for the children's scheme, a resolution trainer, and a parenting coordinator. Thank you so much for joining us, Rebecca.
Thank you for having me, Chloe.
So today, I know you've got many skills, but we're going to focus on arbitration. And I'd love to hear from you. If you could explain to our listeners what arbitration is specifically in the context of a divorce.
So arbitration is, as you said in the introduction, it's a bit like a private court. So insofar as a normal court process takes a very long time, you don't know what you're going to get, you don't know who you're going to get, and the decision is quite risky. It's a bit like the NHS, and BUPA, the BUPA version of court is arbitration. So you can choose your arbitrator, you can choose where it takes place, you can choose the specific issues you want a determination about, and it's a much less confrontational way of having a decision made by somebody else. You're still putting things into somebody else's hands, but you have a little bit more control over how that all works. So yes, it's a private decision.
Well, that's very helpful. Thank you. And are there any specific cases in which arbitration is particularly relevant and useful? And can it be used, in all kinds of cases? What would be your recommendation in terms of when it's applicable?
It's applicable for finance and children cases. So there are different schemes, and arbitrators have to qualify as a child arbitrator or a financial arbitrator. But really, there is very little that an arbitrator can't make a decision on. There are some specifics in terms of, for example, medical treatment for children's schemes, so some very important decisions. But the run-of-the-mill decisions that you would expect in a family divorce and a family breakdown, arbitrators can decide on, they can make a determination.
Can choose to go to an arbitrator if they can't resolve things among themselves.
Yeah, absolutely. And as I said earlier, it's you don't have to have an arbitrator for the whole decision. So if you were looking for, if you're in a financial remedy case, for example, it doesn't have to look at everything. If you're stuck on a particular point in mediation, it would and it helps to be unstuck, then an arbitrator can help with that particular point.
Yeah, I think that's actually a really good point. It really is that kind of last bit when, if mediation can address 90% of the issues and there's just one bit that the couple is still stuck on, arbitration can help just get them over the line and get that finally agreed.
Yeah, or in the middle of the mediations, there might be just some noise that you just can't get rid of or move forward from. But having arbitration then might free up, space to think about the bigger picture.
Very good point. And are there cases where arbitration is not suitable?
Yes, as I said, medical treatment. There are some jurisdictional points in financial cases, so deciding on assets, but perhaps that have been held abroad. There are some very specific cases, and they are listed in the IFLA rules, which is the Institute of Family Law Arbitrator rules.
Okay. And so in terms of how the arbitration happens in practice, you said it was less confrontational than going to court, but do people still come with a barrister? Do they still have a solicitor in the background, or how does it usually work?
Yeah, all sorts. So you have to choose an arbitrator, but if it starts off being quite high conflict and you can't choose your arbitrator, then IFLA, the Institute of Family Law Arbitrators, will do that for you. And then you fill in the forms. There are some procedural aspects. Yes, we have all sorts. So it is possible to have an arbitration with no legal representation at all, and it can really limit your costs. So that can be really helpful. On the other hand, of course, there are clients who need the support of their lawyers. Perhaps their lawyers will do the pack, the bundle of documents, but won't come to the hearing, or if it's not a hearing, won't make any representations. Or you might have the full thing where solicitors have been involved and the barrister is doing the presentation. So it can cover all sorts of cases.
Same as a traditional court of law, really, where you would choose to be self-represented or to come with your own barrister.
Yeah, absolutely.
So you mentioned costs. How expensive is arbitration, since it's the private version of a traditional court hearing? How long does it take, and how much does it cost?
So how long does it take first? Again, it's a matter of choice, because if you are arbitrating about a very specific issue, you can do that really quickly. You can appoint an arbitrator in a couple of weeks and have a decision made very urgently.
That's great.
Let's contrast that with the courts. So, for example, if you wanted a decision about where a child should go to school, that could be dealt with very quickly and would be very effective, rather than appointing your lawyer, preparing all the paperwork for the hearing. You wouldn't get a decision at the first hearing. You would probably need, one, maybe two more hearings. So it can be really effective, and you're really narrowing down those issues. If you are asking an arbitrator to make a decision about the whole thing, the whole picture, then of course there are going to be more costs. And one thing to bear in mind is that the arbitrator is in control, so they may need more information. They may want to have a directions hearing, but I can tell you that it is significantly less expensive than making an application to court. And as I say, you're going to get it in a much more in a much more focused way.
Yeah, and faster, according to what you're saying.
Yeah. So you're focusing on the issues all of the time. You haven't got the court clerk coming in telling you that something else is going to happen. You haven't got a list of cases to be dealt with in that day. Arbitrators are really focused on you.
Yeah, and I love what you were saying earlier around the fact that when you choose to have arbitration, you are keeping some control, because you get to select the arbitrator. It's not up to luck which judge you get.
Yeah, but even if you haven't selected the arbitrator, and if Lo has selected them for you, obviously there are a limited number of arbitrators. So and they are specialists. You cannot become an arbitrator until you've had more than 10 years specialist experience.
Oh, that's great. Okay.
So you are getting somebody who really knows their stuff.
And they've got the experience to back it up.
Yeah.
And so in practice, I guess, trying to put myself in the shoes of somebody who is starting arbitration or contemplating it, what do the sessions actually look like? Are they virtual? Are they in person? How do people, come to the table?
Again, in this modern world, they could be all of those. So people clients can request to have hearings, or they request for decisions to be made on paper.
Oh, okay.
If the arbitrator thinks that it is too complicated to be dealt with just on paper, there may be a series of shorter hearings, but really it's choice. So there are arbitrations that will take place online. There may be a hybrid mix where some people are online, some people are in the room. You could do it all in the room. Yeah. Again, you speak to your arbitrator and decide what works best for you and what works best for you as a couple.
Of course, yeah. That's great. So there is more flexibility, I guess, than with the typical court process.
Yeah, absolutely.
And in terms of preparation, is that similar to going to court? What kind of documentation does the couple need to pull together?
So you'd have to fill out your application form, your ARB1, as it's called, first of all, and that's registered with the Institute of Family Law Arbitrators. And once you've signed up, that's it. You're signed. The arbitrator has to make a decision. So once you've done that, the arbitrator will meet with you or speak to you to get an idea of the issues. They can only deal with issues that you have put in your ARB1. It's really important to make sure that you are thinking ahead and understanding what it is you need a decision on, because the arbitrator cannot make a decision unless it's within scope, it's on that form. So you'll need to prepare the form, and then you have to take some legal advice before signing the form. Once you've done that, The arbitrators expect a bundle of documents, and they're going to work with you to set out exactly what that is. And like court hearings, there'll probably be a limit. The arbitrator is going to want a box of, a courier turning up with boxes of documents, so they'll probably work with you. And certainly if you have legal representation, they'll have an idea of what you need as to what's going in that bundle of documents.
Okay, yeah, that makes a lot of sense. So the big question, I guess, is what is the legal value then of the decision that the arbitrator makes? Is it really the same as the judge in the family law court, or is it less enforceable?
It is binding. So the determination or the award that's made by the arbitrator is binding. Now, I say that there are some caveats to that. So in children cases, the court always retains jurisdiction, and if there is a safeguarding risk, or if there is something that the arbitrator hasn't seen, then the court will retain the jurisdiction when you go to make an award, when you have it turned into your consent order.
Yeah.
In financial cases, they are binding, and they will be incorporated into your eventual financial remedy order. So they are enforceable. They are it's limited scope for appeal, and quite new. There aren't very many reported cases of arbitral awards. There are a few. There were a couple recently where something was overturned. I don't want that to worry clients, because actually this is new, and most of them have been very successful.
So if somebody is not happy with the outcome of the arbitration, can they appeal to the court, or are they bound by what's been decided?
There are limited grounds to appeal. So in the same way as a court appeal, you can't, just because you don't like the award, you can't go and appeal it. There are certain rules around appeals, and generally you're wrong in the law is wrong, or that the facts, or there's some new information on the facts are wrong. So yes, it's quite limited. This person, you are appointing them to be your judge.
Yes. It's a very different mindset than the other alternative dispute resolution approaches.
Yes, yeah. It's interesting when you compare it to other jurisdictions who've been using arbitration for some time. And not just other arbitrations, but other jurisdictions, but other areas of law, because it's really common in shipping, insurance, construction, because they are specialist industries. And I think that's where arbitration can be really helpful in the family arena.
So is it a fairly recent trend in the family arena that arbitration has been an option?
Since the 2000s.
So, okay. Oh yes, so it's fairly recent.
The Arbitration Act was 1996, but in terms of the family scheme, they're quite recent. So yes.
And do you find that people who come to you for arbitration have usually tried mediation before, or do they come straight to you, or how does it usually work?
We've had arbitrations where they have been sent by their lawyers instead of court, which has been quite nice. So they may not have tried other areas first, and they are cases which need somebody else to be involved. And we have had cases where they have come from mediators. So they've been involved in mediation, and as I said, they just wanted something sorted, and then they can get back to their it's interesting. It's like all things, it has a place, and it's not going to be suitable for everybody, but it is probably far more suitable than court.
Yes, I think that's the message I'm really hearing from you, is that it gives you all the benefits of court in the sense that somebody makes a fair and impartial decision, and it's binding, but you don't have to deal with as much expense. It certainly doesn't take as long, and you maintain a degree of control because there is that choice element around who the arbitrator is.
Yeah, absolutely. So it's court still has a place. There are a certain number of cases that will need to be investigated by court, but arbitration really fills the gap for that they're not quite suitable for mediation, or something a bit more than mediation, but actually we don't need a judge, we don't need to use the time and resource of the court.
The big advantage is you get to choose specifically what the arbitrator is going to make a decision on. It's not necessarily the whole case.
Absolutely, yes. Yeah. The other
That's
thing
really helpful.
that we do here is I suppose what you'd call med-arb.
Mm-hmm.
Some clients in mediation, they want the certainty of knowing that they are going to have an end to whatever it is they're talking about.
Yeah.
And so at the beginning of the mediation, we appoint an arbitrator. Just
Okay.
in case they need to use it.
Oh, that's great. Okay, so they have it as a backup if mediation doesn't solve everything.
Yeah, so it's very inventively called med-arb. But yeah, so it gives them this certainty at the very beginning that we'll help them all we can in mediation.
Yeah.
We'll appoint and choose their arbitrator, and if really we can't take them any further along the pathway, then they will then go off to that arbitrator, or we would be appointed.
I guess since you work as a mediator as well, I assume that if you've been a mediator on a case, you wouldn't be the arbitrator as well. They would choose someone else, or would you follow the case through?
Completely. There would be a conflict, and even though I could put up firewalls, I wouldn't pass one of my mediation cases to Claire, who is my partner here, who's also an arbitrator. That just wouldn't sit comfortably, and I think there'd be some concern about conflict.
Yeah, makes sense. So the last question that I always ask at the end of all of my podcasts is for 3 tips. So in your area of expertise as an arbitrator, what would be your 3 top tips to a couple that's considering arbitration to resolve their divorce disputes?
My first tip is to make sure that you are specific about what you are asking your arbitrator to make a determination or award upon. My second is, like all options and approaches, this is a people thing and a communication thing. So speak to arbitrators, speak to them, get a feel for their expertise. You can shop, you can make sure that you're all comfortable with somebody. And thirdly, I would have some legal advice. So even if you were thinking about representing yourself, understand what it is that the long-term implications are going to be. So with whether or not you're in mediation and it progresses to arbitration, take some advice so that you just know what you're going to be in for.
It sounds like that legal advice would also be really important, back to your very first point around being very clear about what it is you're asking the arbitrator to determine.
Yeah, I think that's absolutely right, Chloe. It's just making sure that you've got that written down in a really concise way from the outset.
Really helpful. Thank you so much, Rebecca. It's been really great speaking to you. And thank you for sharing all your insights. It's brilliant to speak to someone who knows so many different options within the ADR space.
Oh, thank you. It's been a real pleasure today. Thank you.
Have a great day. We'll speak soon.